show, does the top monitor have anything on it or is it just off right now?
Start off.
So do I need to send to Service Desk Plus a request to get the Ethernet jack under the prosecution table fixed and to get this Wi-Fi fixed, or is that already in the queue?
Wi-Fi's fine. I would put the ticket for the.
Just so we have a tracking.
Yeah, no, I'm all for doing it, but if I were to put Wi-Fi, that would be doing a duplicate ticket. You already have one for Wi-Fi for that. Okay, great. Thank you. All right, Ms. Rivers, are you ready? Great, let's go on the record in State versus Williams. It is Friday, we're still in trial. It's a little after 9. We've got our prosecutors, our defense attorneys, Mr. Williams is here. All our jurors here?
Yes.
Our jurors are ready to go. I have provided each of the 4 lawyers with a copy of the proposed final charge. I also shared a verdict form. Mr. Abate, did you get a chance to look at the verdict form?
I did.
Any issues?
I just had a question, an inquiry. I wasn't, logically to me, it doesn't seem as if the voluntary manslaughter and involve would be lesser included for criminal damage to property in the first degree. Obviously, I get the one as it relates to the felony murder and the aggravated assault. But to me, that seems like it would be kind of where you have felony murder predicated on, for example, possession of a firearm by a convicted felon. In that instance,
Right. No, it's a good question. Ms. Feely, what's your thought about that?
We didn't have any objection to the verdict form.
Okay, I didn't ask my question well. What's your thought about Mr. Abate's question?
I think that is kind of the basis of felony murder, is to have a second bite of the apple, even if they don't think he acted with malice if he caused the death of another through the other two counts. So I agree that it's not a lesser.
Okay, for the criminal damage.
Right.
Okay, so count one verdict form, fine. Count two verdict form, fine. 4 options for both of those, but counts 3 through 6 should all just be guilty, not guilty. That's your proposition. Okay, I think I agree with that. I just was sort of methodically going through murder, felony murder, and having them all look the same. It sounds like you believe that is legally correct, Ms. Feely.
Yeah, so we're talking about counts 2 and 3.
So, well, the verdict form for count 1 will have 4 options for the jury. Count 2 will have 4 options for the jury. Count 3 would simply, there'd be the option of guilty. I won't say of felony murder anymore. It would just be guilty, not guilty. So 3 would be like 4, 5, and 6.
Understood. Okay.
Okay, all right, I will fix that. And that'll actually make what I need to do with the jury charge easier. Anything about the jury charge that you want to discuss based on our conversation last night, Mr. Abate?
no, Your Honor.
All right, Ms. Feely, anything more? You had objected to revenge, so you've preserved that. Anything more? Okay, then I think we're good with the jury charge. You're ready, Ms. Feely, with your closing?
Yes.
Anything else before the jurors come in? Mr. Abate, you're ready with the part 2 of the state's closing when Ms. Feely's done.
That's correct, Judge.
All right, and welcome Ms. Nix. Hold on one second. Do you want me to introduce Ms. Nix to the jury, or just explain, or just do nothing?
Do nothing.
Okay, I think it is anonymous woman at the table. We'll do it that way.
All right, for the jury. Judge, President, the council.
Thank you, Deputy Gordon. Everyone else can be seated. Happy Friday, jurors. Thank you for being here on time. We are ready to continue. We ended last night with Mr. Rao presenting the first part of the state's summation or closing argument. Now is the time for Ms. Feely or Ms. Rios, should they choose to give closing or summation on behalf of Mr. Williams. Should that happen, when it's done, then Mr. Abate has told me that he does plan to give a rebuttal or a final part of the closing argument. And that'll be it. I'll give you the jury charge and you'll begin your deliberations. Ms. Feely, if you are ready.
This was not a murder. That's what I told you in opening, and that's what this trial has shown. This was a horrible, tragic shooting death, and nothing that anybody else does at this point changes that. But this was not a murder. We, as a defense, have raised the affirmative defense of self-defense. And the state must now disprove that beyond a reasonable doubt. So you can find that Mr. Williams committed the shooting, but did so under circumstances under which it was justified. The state cannot disprove that Mr. Williams acted in self-defense because the only two who witnessed the shooting were Mr. Williams and Mr. Hardesty. The state cannot have it both ways. The state may accuse the defense of trying to have it both ways, but it's the state who wants you to believe that Marquez was never robbed, was never beaten by Mr. Hardesty, was never in any violent encounters. And so where does that leave you? Does the state really want you to believe that Mr. Williams shot at a stranger for no reason? They can't have it both ways. Mr. Williams was afraid based on their prior interactions and based on their encounter that night. There is no other explanation for Mr. Williams firing those shots but fear. So not only does the state have to prove beyond a reasonable doubt that Mr. Williams shot Mr. Hardesty, but they have to disprove that those shots were fired in self-defense. So reasonable doubt is a very high standard, and it's difficult to kind of conceptualize, but it is a reason, a doubt for which a reason can be given. So if you are back there and you think maybe Marquez just shot a stranger for no reason, maybe is reasonable doubt. If you think he probably, for no reason, shot a stranger, that is reasonable doubt. And then you have to flip it. If you think maybe he was not acting in self-defense, he probably was not acting in self-defense. If you think he most likely was not acting in self-defense, that is not guilty. The state must prove beyond a reasonable doubt that this was not self-defense. Let's say you have tickets to a very expensive concert, right? And you're going to leave the house. You check your pocket one last time before you walk out the door and make sure you have your tickets. That's reasonable doubt. Don't walk out the door. Don't render a verdict without making sure you have the evidence in your pocket. You're gonna get, the judge is gonna instruct you on the actual elements of each crime, and you have to take them, each one. The state has to prove each element of the indictment for each crime. So we talked about what reasonable doubt is, and it's helpful to think also about what it is not. Reasonable doubt is a higher burden than grave suspicion. So even if you're back there and you are gravely suspicious that what Marquez did was not self-defense, that's not sufficient. It may feel like it is, but if you are back there with grave suspicion that this was an unjustified shooting, that is not guilty. Intent is an element that you cannot presume. You cannot assume intent. The state must prove beyond a reasonable doubt that Mr. Williams intended and was not justified in his actions. And intent is particularly important with the count that you'll get back there with criminal damage. The state would have to prove to you beyond a reasonable doubt that Mr. Williams intended criminal damage to property in the first degree. We talked about this in opening as well. There is no other emotion you can feel when you see Ms. Cook, when you see family members. These people lost someone that they love, and there's no reason not to feel sympathy for them. It's natural, and we're not asking you not to. The only thing we are asking as a defense that you do is follow the judge's instructions. You can feel that, but you cannot base your verdict on it. It's difficult, and we recognize that, but you took an oath to do it. The judge is also going to explain that your verdict must be unanimous, and that's true. You all have to agree. And we talked in jury selection about if your opinion differs, certainly deliberate, but never relinquish your strongly held belief after talking with everybody, just to be congenial. This isn't about congeniality. This is a very important case, as you can tell. So your verdict has to be unanimous, but we don't all have to agree on why. So let's talk about the reasons to doubt in this case. Some of you may not be able to get past the fact that there is no physical evidence tying Mr. Williams to this scene. This is a murder case. You heard about the investigation. They didn't even find shell casings until January 4th. This lack of investigation, this faulty investigation, is exactly how wrongful convictions happen. There's no DNA. There are no fingerprints. We don't really know because nobody else was there, and there is no actual evidence. Just tell us what happened. No gun. This is a murder case. This is a shooting case. There's no gun taken into evidence. There was a gun found, and it was photographed. We don't know if it was fired that night. We don't know if it was in the car. We only have Ms. Cook, an understandably biased witness, telling us she got it out of the apartment. That's the only evidence we have of that. We don't know what type of gun necessarily. We heard testimony that it was a 22, but nobody fired it. It was a 22 magazine. If it was a revolver, it wouldn't have had shell casing. So if there had been an exchange of gunfire, there would be no physical evidence in terms of shell casings. But we didn't have shell casings from the third floor either. The state was operating under the assumption that this all took place on the first floor until they happened to go back and a helpful neighbor happened to point out, there's some shell casings up here. Maybe that's related. This should not be the standard in Fulton County in 2024 for investigating a murder case. No gunshot residue. You heard from Dr. Sullivan as well as Detective McClure that there is a process by which a body can be tested for gunshot residue. And Detective McClure tried to get cute. Oh, well, any gunshot wound victim would have gunshot residue. But that wasn't my question. My question was, can you test for residue that is consistent with someone firing a firearm? In which case you would test both of their hands and there would be a higher concentration there. So So he tried to skirt that, of course, because he didn't do it. So he wants to make it seem not important, but it is. The state could have presented you with evidence definitively saying, or very close to definitively saying, this man did not fire a gun that night, but they chose not to. So and now we don't know, we will never know whether there was gunshot residue on Mr. Hart's hands. The state yesterday made a big show of how Robin Cook's testimony is uncontroverted, not contested at all, must be the truth. And in fact, the state actually said that. She's being honest, she's being truthful. Well, guess what? It's not up to them. It's not their opinion of their witnesses, whether they're being truthful. It's up to you. So they can bolster all their own witnesses and say things like that based on nothing. Mr. Rao wasn't there. Mr. Rao doesn't know whether Ms. Cook is telling the truth. Witness credibility is for you to determine. But the thing that we can all agree on about Ms. Cook's testimony is that she did not see the shooting. She didn't go down with him. She did not see the gunman. She was not a witness to this crime. But she did tell you that she went to the car. Could she have removed something from the car? Could she have, we don't know what she would have done to the car, but we know she went to the car because she testified that when she opened the door, the glass fell. And hopefully y'all caught that. She opened the door. She lives in this neighborhood. She knows this is now a crime scene. This car is getting towed and it's getting processed. That's logical for her to think that. So she goes to the car. We don't have any information about what she may or may not have done when she was at the car, or what property she may or may not have removed. But you will have defense one back there with you, or you can ask to see if it's not back there. But in defense one, which is crime scene investigator Brandon Parker's police report, look at it and see for yourself what makes sense. She's been doing this for 8 years. She's now a supervisor. She's good at this. She wouldn't make a sloppy mistake like saying, I was, I guess, processing a Ford Explorer. I saw bloodstains, a gun, 2 shell casings, and a bullet fragment, when what she meant was the gun was in the apartment. That does not make sense. And you heard from the second crime scene investigator who's only been on the job today, as of this week, 2 years, which means he was very new to the job when this incident occurred and he investigated it and was part of the investigation. And he even confirmed. He didn't just write shell casings. He wrote in his report where they were. He documented where the shell casings were. So for a gun in a murder case to not be documented where it was, that should not be acceptable to you. That is a reason to doubt in this case. We heard from Ms. Smith, who testified and told you that after she heard the gunshot, she heard a car speed off. Mightn't that have been somebody who saw or knew something about this or was involved? No effort was made to track any movements of anyone else except for this one person. Despite the fact that Ms. Cook tells you she thought it was more than one person. She heard more than one set of footsteps. They didn't go to the 3rd floor to see who was up there. That makes a lot of more sense than other things, that somebody involved in the shooting, you heard running on the 3rd floor and doors opening and closing because that person went in their apartment because they live on the 3rd floor. It's a reason to doubt that there were more than one people involved in this. Ms. McCluster told you that she had known Marquez for a long time, and she saw what was shown to her, and she didn't think that looked like Marquez. That looked like a disguise. And you heard, or at least saw, that Mr. Williams has an older brother who lives there as well. You didn't see any pictures of him or any evidence of him. But the person who actually knew Marquez, who testified, said that did not look like him. Marquez Williams. Robin Cook's testimony was uncontroverted, but so was Marquez's. There's nobody who took the stand to say they saw something different than what Marquez testified to. The only two people who know what happened are Mr. Harsey and Mr. Williams. And the only thing that makes sense is what Mr. Williams tells you. Mr. Williams didn't tell the whole truth to Detective McClure. You can think of reasons why that might be reasonable in his young, not fully mature brain and his relationship to the police. But what you did hear, and Detective recorded with you, is that Mr. Williams is not a felon. And you hear that when he says, "So you had a gun. So what? You're not a felon." So Marquez has limited experience dealing with police one-on-one in that type of situation. But he wasn't under oath when he spoke with Detective McClure like he was yesterday. And he isn't saying anything wildly inconsistent with what he told Detective McClure. He just didn't tell Detective McClure the whole truth. And again, you don't have to get in his head and try to figure out what his rationale was for that. But I think he says at one point, nobody's ever tried to help, like, the police never tried to help me. Is that a good attitude to have? Maybe not. But Marquez grew up where he grew up, and he's had the experiences he's had. The state will probably make a big deal out of Marquez doing a better job answering my questions than the state's. And there are several reasons for that. One, I asked a fraction of the amount of questions that the state asked him. I asked him probably less than 20 questions. Maybe somewhere around in there, because to help him tell you what happened. And he knows the way I speak, the way we've conversed. And I'm not a trained prosecutor. I'm not trained to cross-examine people on the stand like that. And you could see him, the state tried to make it sound like he was being evasive, but you could see him having trouble processing, having trouble focusing on the questions. But he told you what happened. And there's no witness that can take a stand to dispute what he says, because it's the only thing that makes sense. And if you are back there and you think it started as self-defense, maybe it was a little bit excessive, something like that, that still is not murder. I don't think we get all the way there, because the state is only going to focus on the shots. But Dr. Sullivan told you that even she, with all of her advanced degrees and all of her training experience, 4,000 autopsies, she did not take the stand and commit to the body was in a certain position when it was shot. she committed to, it's like a game of Twister, you don't really know. The first shot could hit the arm, and then the person falls. And this is not like target practice, this was immediate, all of the shots at once. You heard that from the witnesses who said they heard gunshots in quick succession. So if he was pointing a gun at Marquez, gets shot in the arm and falls, the other shots understandably would hit him. But that is the state's whole case, is the gunshots being where they are. But this happened so quickly. And even Dr. Sullivan can't tell you that where the body was positioned at first. And so. You will have the verdict forms, and while you're deliberating, it's very important that you understand that murder is murder is murder. The state has to prove malice, the state has to prove all of the elements of murder and disprove that Mr. Williams was acting in self-defense. So don't think that felony murder is like some kind of compromise, because it's not. The final reason for doubt I want to talk to you about is the fact that there is not a video of this crime. There's video of everything else. There is not video of this crime. Is that just a coincidence? We don't know anything about the interaction between the two of them. We don't know what the timeline was in terms of Mr. Hardison coming downstairs. That is so critical that if you are back there and you find yourself saying, I sure wish we had a video, that is reasonable doubt. And you should be thinking that. There should be a video. Much like the gun not being taken in, what else is there? You would not be sitting here if there was a video. Because we would know that Mr. Williams shot in self-defense after he was in a scuffle with a man who had robbed him and beaten him in the past. But we don't. And so if you wish we had one to give you peace of mind before you convict someone of murder, that is reasonable doubt. I don't think you get all the way to voluntary manslaughter because Mr. Williams was acting in self-defense when he shot, but if you get there, you know that something happened. It does not make sense that Mr. Williams would shoot a stranger for no reason. You know something happened, at the very least. It doesn't make sense that he would, that worst case, that he was provoked. If you are back there and you don't know what it was, but you know something happened, that this was not just a completely random stranger, absolutely no reason shooting, you may not return a verdict of guilty on the murder. In that case, even though you don't know what the confrontation was, you could return the voluntary manslaughter count. But to get all the way to murder, the state has to prove to you beyond a reasonable doubt, and you have to be convinced beyond a reasonable doubt that this was a stranger to him. He just shot them. Nothing happened before, nothing since. This happened in a vacuum according to the state, if you want to get all the way to murder. That's not what the evidence has been. This is also an option that will be on your verdict form. If you find that Mr. Williams, when he shot, that was reckless and it caused someone's death, you would be authorized to commit involuntary manslaughter. again, we talk about burden of proof, and it's so difficult. It's impossible for me to overstate how important it is that you hold the state to their burden. They must prove every element of murder, and they must prove to you beyond a reasonable doubt that this count should not be reduced to voluntary manslaughter. And to do that, like we talked about, they would have to prove to you that nothing happened. This was malice, this was just, he shot him. Nothing happened before, nothing happened in the past, this was random. This was malice. They must prove to you beyond a reasonable doubt that this should not be reduced to voluntary. Going back to the bigger picture, if this case is a mess, this investigation is a mess, the whole situation, you don't know what happened, and that's a problem for the state. Because if your minds are wavering, unsettled, or unsatisfied, if you are unsatisfied with the lack of video, you couldn't see what happened. That is a doubt of the law, and it would be your duty to acquit Mr. Wilkins at that point. It's not gonna be fun. There is some grieving family, but if your minds are wavering, unsettled, and unsatisfied, which they should be, you must acquit Mr. Williams. And so we are asking you to do what you were chosen to do, knowing it wasn't going to be easy. And base your verdict on the evidence that is presented to you and find Mr. Williams not guilty.
Thank you, Ms. Feely. Mr. Abate, you ready?
All right, the spinning wheel is finally gone. told you at the beginning of this trial that there was one word that described the actions of this defendant on December 22nd of 2022. One word to describe the 5 gunshot wounds to the backside of Mr. Hardesty, and then the additional 1 grazed wound also to the back arm of Mr. Hardesty. And that one word defined by the laws of the state of Georgia is murder. That's it. Murder. This defendant on December 22nd of 2022 murdered Tyrone Hardesty. He murdered him in cold blood. Detective McClure said it best as he was talking during the interview with the defendant, telling him, this looks like one thing, this is like cold-blooded murder. You gotta explain some stuff, well, this is cold-blooded murder. And he explained nothing. He explained nothing in his interview. He explained nothing but lying to you yesterday. And all of that proves that he committed this murder and killed Tyrone Hardesty in cold blood. Now, I want to talk to you a few things about what Ms. Feely just addressed with you about the lack of physical evidence, or no doing the GSR test not being done, or not having a gun, or the .22 caliber not being tested. None of that matters. He admitted to shooting the victim in this case. The defendant told you that he shot him. The defendant told you that Tyrone never shot. So we know there was only one gun fired. All of that is irrelevant. All of that is smoke and mirrors in an attempt to distract you from the truth, in an attempt to prevent you from being able to go through and sift through all of the facts and finding the truth that this defendant killed Tyrone in cold blood. Ms. Feely talked to you about why. We don't know why. But you heard from Mr. Rao yesterday, and you'll hear from the judge today, that the state doesn't have to prove motive. The only person who knows why is this defendant. We're not in his mind. He sure didn't tell you yesterday. Made up a whole bunch of new stories yesterday. But whether we know why or not, the physical evidence, the investigation proves the 5 shots to the back shows that this defendant killed Mr. Hardesty in cold blood. That he laid in wait at an elevated position, in a position that he could see but could not be seen, in a position where he had a tactical advantage over his intended target, because that's what Tyrone was. He was a target. That position allowed him the element of surprise. And when Tyrone walked out of his apartment from celebrating Christmas, wrapping gifts with his fiance, trying to do what most people do on December 22nd, days before Christmas, enjoy their family, enjoy their loved ones, feeling the stress of not having enough gifts or last minute shopping that must be done, that was ruined, that was robbed. The only person who robbed anyone was this defendant. On December 22nd of 2022, he robbed Tyrone of his life. He robbed Tyrone's family of a son, of a brother, of a father. He robbed Miss Cook of her fiance, the person she planned to spend her forever with. He robbed them of all of that. He stole that from them. But the facts show that Mr. Hardesty was unarmed, that he was shot unexpectedly and unknowingly 5 times in the back. And how do we know that he didn't know he was being shot at, or that he was being watched? And this whole argument that the defendant talked about yesterday that occurred in a time period that is impossible based on the actual timeline. Because, and we'll get to it here in a second, But if you're looking at the crime scene photos, and if you remember how Mr. Hardesty was slumped over inside of his vehicle, literally reaching for the flyers. And if you notice that it's clear he didn't have the ability to run or move, he had no idea he was being shot because he literally just falls into the car. That's where you see all of the blood pool. You can see there was absolutely no clue, or he had no idea he was being shot at. And I submit to you, ladies and gentlemen of the jury, that the first shot that he received was the one in the back of the head. And you heard from Dr. Sullivan that when he received that shot to the head, that shot to the brain, it was lights out. That it affected the way his heart pumped, hit his femoral arteries, he bled out immediately, he drowned in his own blood. But that wasn't enough for the defendant. He continued to shoot from that elevated position as Tyrone Hardesty drowned in his own blood, alone, in pain. And what you saw yesterday was the defendant is remorseless. Remorseless. All of that shows you his intent of all of his actions on December 22nd of 2022. His intent is shown through the fact that he immediately left the scene of the murder. And we know that he left at the time right after it happened, unlike what he told you yesterday, is because 911 was called at 9:06. And you see him on that video leaving the apartment at the exact same time. He told you, and he told Detective McClure, that after the murder, he got rid of the gun. He got rid of the murder weapon. All of that goes to his intent. It shows you that he intended to maliciously kill Tyrone Hardesty. Also, looking towards that you can use his conduct in order to prove his intent. His conduct before the murder, during the murder, after the murder. And some of this we just talked about, but before you have Ms. McLester saying the defendant was dressed in a disguise. Not that it wasn't him, but he was dressed in a disguise. That he has disguised his face and he was dressed in all black. But that's because it was cold outside. But he wasn't wearing a mask on January 8th, but it was just as cold outside. He laid in wait at the third floor of building 1, the building that Tyrone had lived at for the last 3.5 years with his significant other, Ms. Cook. The only reasonable explanation for the defendant being 1 floor above where Tyrone lived and the building in which he lived, armed and ready to shoot, is because he was there to take Tyrone's life. That's the only reasonable explanation. Why? I don't know. We'll never know because he didn't tell us. And after he left the scene, he got rid of the gun, he never contacted authorities, and he lied to Detective McClure over and over and over again. Now, the judge is going to instruct you on a jury pattern charge called revenge. What he's going to tell you is a defendant is not justified in threatening or using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. Using force that ends in death for the purpose of avenging a past wrong is murder. So if you were to believe, for argument's sake, that Tyrone had robbed the defendant in the past, that's what he did that night is murder. Now, I submit to you that Tyrone never robbed him. There was absolutely no evidence that he robbed him. You heard from Detective McClure, he did, through his investigation, after speaking with the defendant, looked up the 2020 robbery. Tyrone Hardesty, not a suspect. He looked for 911 calls and reports and CAD reports as it relates to any other robberies after the 2020 robbery, where he described the males as black young juveniles. No CAD reports, no other reports for those 2 robberies. And then he looked for any report from the last couple of days, as the defendant described during his interview, that he had been robbed by Tyrone a few days earlier, and then held at gunpoint and forced into his car and then taken back to his apartment, where he was then released after, I think he said $20 was taken from him, and said he was gonna kill his family. No reports, no calls, no nothing, no documentation of any of that. And I submit to you, ladies and gentlemen, there's no documentation of any of that because it never happened. It never happened. The fact of the matter is that this defendant murdered Tyrone Robinson on December 22nd, 2022. There's no other way to put it. There's no other way to see the evidence. That is what it shows. That is what the state has proved beyond a reasonable doubt. Now let's talk about some of the defendant's own statements and words. And we'll start with the lies he told Detective McClure when he was arrested on January 11th of 2023. And you hear him at the very beginning of the interview. I think it's around I think it was 07 into the interview, 217, where he's talking to himself saying, I don't know why I'm here. I didn't do anything. I don't know nothing about a murder. Then Detective McClure enters the room, Mirandizes him, asks him if he wants to speak to him, reads him his rights. He agrees. He wants to speak. And you saw the interview. He didn't ask any questions. He didn't say he didn't understand. His answers were coherent. And the interview continued. Detective McClure shows him a picture of himself where he denies the picture is him. In fact, he tells Detective McClure that that's probably one of my mom's massage clientele. And we all heard what happened after that picture was sent to his mom. There was no affirmation that that was any sort of clientele as it relates to her business. He then is shown a picture of the victim. Detective McClure shows him a picture of Tyrone Hardesty, and he says, never seen that guy before. Never seen him before. He then goes on and comes up with this elaborate lie that he was at his cousin's Tay's house on December 22nd of 2022, who lives at 5110 Marked Farms Lane in Powder Springs, Georgia, Cobb County. He goes into that great of detail. He provides an address. All of those things continue to lie, to try to detract and distract Detective McClure from his investigation. All beknownst to him that Detective McClure had collected all of this video surveillance, that he'd gotten video surveillance from the peaks at the MLK, from the Columbia Commons, the lease, that he'd spoken to Mr. Sengupta, that he'd spoken to Miss Smith, and that he had recently gotten a ring camera from Miss Smith. Excuse me, Miss Winder. Then after about 40 minutes into the interview, Detective McClure changes the trajectory of that interview using the tactics and the techniques that he's learned through his 14 years with the police department and the last 8 in homicide. That is an olive branch. If this is self-defense, man, just tell me if you acted in self-defense. The defendant jumps on that real quick. Says that he threatened me, he threatened my family, he robbed me in 2020. Except there's no evidence of that. He robbed me 2 more times after the 2020 robbery. Absolutely no evidence of that. He robbed and threatened me a few days before the shooting, except, again, there is 0 evidence of any of that. Nothing. No documentation, no reports, no calls for service, nothing. But he explained that this was traumatizing and scary. The only person who experienced trauma on December 22nd, 2022 was Robin Hood. You all heard the 911 call she placed after finding her fiance dead in his car. Dead in his car. after she just thought he was going out for a few seconds, get some flyers, put in his gifts. And so imagine the trauma she felt when she is in the house thinking she's got a few seconds to herself and she can wrap these new shoes, and she's excited to give Tyrone the joy that she's feeling, that she described, and the reason she wanted to get the gift wrap, because Tyrone had surprised her earlier that day and put a bunch of presents under the Christmas tree. To then hear a series of gunshots while he's outside that door. And then to see what she saw as she walked down those stairs. Her fiance slumped over dead in his car. And seconds earlier, they were wrapping presents together. That's who was traumatized. That's who felt trauma. That person will never be the same because of the actions of this defendant. The actions he has absolutely no remorse for. He then goes on to say that he didn't have a gun that night. I don't know if you remember listening to Detective McClure's response, but he says, come on, man, he was shot. He was shot 5 times. You had a gun. And that's when, as Ms. Fields talked about, he says, you had a gun, you're not a convicted felon. That's why he said it. He was trying to get him to, or push him to tell the truth about something that he literally could not hide from, because Tyrone was shot 5 times in the back. He eventually gives in and says, yeah, I had a gun, I got it off the street. Detective McClure says, well, what did you do with that gun? He says he gave it to some friend who went to college, he doesn't know where it is, it's gone. Detective McClure then asked about whether he saw the victim with the gun. He said he wasn't sure, and he said he knows the victim didn't shoot back. That's what he says after the 40 minutes of lying about not knowing anything about the shooting, not being there, not being a part of it. Then you heard the jail call yesterday from November 23rd, 2023, roughly a year later, 11 months from the date of the homicide. And you hear him talking to his mom on an off-pin call, not using his own pin. And I submit it's because he didn't want anyone to find it. He didn't want to hear. He didn't want anyone to hear the strategy he was trying to come up with, conjure up. He has his mom call his cousin on three-way. He requests his cousin to call a friend, and he gives the IG name, doesn't give the actual name, doesn't say Derek Bailey, as you heard from yesterday, saying that you tell him that we just smoked weed, we hung out, and tell him to say he knows nothing else, he knows nothing more. He knows nothing else, he knows nothing more. Those are his words. And he's saying this despite already giving a statement to Detective McClure saying he did it. So if you're thinking, doesn't make sense, I'm thinking the same thing. Doesn't make sense. But again, murder's not supposed to make sense. Then from yesterday, you heard his testimony as he sat before each and every one of you. And I'm sure there were times that I was thinking myself, and I'm sure you were thinking that I'm asking one too many questions, sit down, you know, whatever. But I submit to you, ladies and gentlemen, the state has one shot. We have one shot at presenting this case to you, the ladies and gentlemen of this jury. We don't get 5, 6, 7 shots like this defendant took at Tyrone. We get one. So I apologize if I spent too much time asking one too many questions, asking the same question, trying to get him to make sense with some of his answers. But the point was to show you is that as he's thinking about, or as the questions are being asked and he's asking them to be repeated, it's not because he doesn't understand the question or that he didn't hear the question. He needs time to come up with details. Details he doesn't have, details he can't keep straight. Ladies and gentlemen, the truth is not a story that you struggle with, because there's only one truth. But when you lie, you gotta keep it straight. And that was clear yesterday, he couldn't do that. That was clear yesterday, he came up with some whole new armed robbery that he had never told anyone about. This whole new encounter that he had with Tyrone on December 22nd. He stuck with still going there for weeks. He told you he traveled through the breezeways. He went through one breezeway, then the next one, and then went to the meeting spot. Couldn't remember where the building actually was. He said he only waited a few seconds, and his friend never showed up, so he left. He didn't try to contact his friend. He didn't try to go to his friend's apartment. He just left. And what he told you yesterday, ladies and gentlemen, is that as he left, he runs smack into the center, or smack into Mr. Robinson, excuse me, Mr. Hardesty. And I apologize, my best friend growing up was Tyrone Robinson, so it is something I have struggled with this entire trial, so I apologize. But as Mr. Hardesty's coming down steps from the second floor, he says they run right into each other. And he's masked up in his black clothing, but somehow he doesn't recognize Tyrone. But Tyrone immediately says, I remember you. I remember you. And his response to I remember you is, I've got $5, can I buy some cigarettes? And then he tells you, Tyrone pulls out his gun, points it at him, directs him to the wall in the middle of the breezeway, holds him at gunpoint, pats him down, takes $20, not the gun that he's got in his jacket, he says, but just the $20, and then hits him with the butt of the gun at least once or twice. But there's no evidence that there's any blood in that area of the crime scene where he had been hit, or he told you he had been hit. Then, as he goes to hit him for a third time, he's able to block the gun, knee Mr. Hardesty in the private area, and somehow the magical gun is launched from the area in the breezeway to the road where the car was parked for the parking lot. That's what he told us yesterday. And then after the gun is launched into the parking area near the back of Mr. Hardesty's Explorer SUV, he says he sees Mr. Hardesty, who he had just kneed in the privates, go for the gun. So instead of either running right around out down the exit ramp of the apartment complex that peaks at MLK, or instead of running straight through the breezeway, the same way he'd come in, out of the apartment complex, he instead decides to take what he says is the safer and easier route to safety. He goes up the stairs, which I submit to you, ladies and gentlemen, makes absolutely no sense, because running straight is a lot less arduous on a person than running up 3 flights of stairs. And so that's what he wants you to believe. He ran up 3 flights of stairs because that was safer. And when he gets to the top of the stairs and goes towards the balcony breezeway area, he looks over and peers over the balcony and sees Mr. Hardesty at the bottom. He's got his gun now. And I guess based on what he told you yesterday, Mr. Hardesty was not concerned at all with the victim, or excuse me, the defendant, as he ran up the stairs, because after he got his gun, he went to his car, opened his rear passenger door, then he turned, and then he said trained the gun on the defendant. And as the defendant's peering over and looking at Mr. Hardesty eye to eye, he's got that gun still pointed at him, and the defendant told you he didn't begin to converse with him, as he's got a gun as he described, trained, pointed at his body, face, whatever you want to call it. And he says, "I'm sorry for needing you in the private area," is what he told you yesterday. That's how it worked out. And that there was a series of yelling going on at the time. And I don't know if you recall, but Miss Smith lived right in that area. She didn't hear any yelling. She told you all she heard was gunshots and then car wheels squealing in the area. Not yelling, no argument. Ms. Cook told you she didn't hear anything other than gunshots. But the defendant wants you to believe there was this big exchange from the top of the third floor balcony and where Mr. Archie was by his vehicle. And he gave you a couple renditions about when his gun came out. First, it was in his jacket pocket and he pulled it out when he got to the top. Then he changed the story and told you that as he was going up the stairs, he was able to pull the gun from his jacket pocket. But as he was looking down and apologizing for kneeing Mr. Hartsey in the private area, he had his gun out, but Mr. Hartsey couldn't see it. But Mr. Hartsey was still pointing the gun at him, trained at him, as they continued to yell at each other. And that's when he shot. And he told you that he shot with the gun in his left hand, and he's right-handed, and he had his right hand kind of covering his face, his eyes, and he shot and didn't know where he was shooting. If you're thinking that sounds ridiculous, it's because it is. It's ridiculous. It makes no sense. Because Tyrone Hartsey is shot 5 times in the back with a grazed wound, for a 6th shot in the back of his arm as well. And he told you he shot 6 to 7 times. He shot 6 to 7 times at the body of the vehicle of Mr. Hartsey. That's what the facts show. Those are uncontroverted facts. It's uncontroverted that he shot from the top of the third floor balcony. Mr. Hartsey was leaned into his vehicle. After shooting 6 to 7 times, he says he didn't know that he had hit Tyrone and that he just ran scared because he was afraid that Tyrone was coming back and was going to follow him to wherever he was going, his house, in his car. But when he spoke to Detective McClure, he said he watched Tyrone fall. He said that in the middle of his interview towards, I think it was about 2 hours and 57 minutes into the video, where Detective McClure is asking him about whether Tyrone had a gun, like we talked about. He said he didn't know and that he didn't shoot, and then he watched him fall. But all of that changed yesterday. But the truth is in the timeline. The truth is in the evidence and testimony as it unfolded before each and every one of you over the last 4 days. And what the timeline, the uncontroverted, unchallenged timeline. And I want to be clear, Ms. Cook's testimony was unchallenged, uncontroverted. There were no questions asked of Ms. Cook. There was no contradiction to Ms. Cook's testimony. But that is uncontroverted. That's exactly what that means. It is unchallenged. And she told you at 6 p.m., her and Tyrone met up at the Dollar Tree where she was with her grandmother, that they then dropped her car off at her grandmother's house, and they began to run errands, and they went to Walmart. They went to the Walmart off of Ashby, where during the processing of the vehicle, Detective McClure and Crime Detective Parker actually found a Walmart receipt in Tyrone's Explorer with his wallet, stamped 8:24 p.m. for December 22nd, 2022, corroborating Ms. Cook's unchallenged testimony. Then you see at 8:44 p.m. the defendant in all black with his mask walking up the entrance ramp of the MLK Peaks apartment. At 8:48 PM, you see Tyrone's 2006 Ford Explorer drive up the entrance ramp and around the bend to go park. Then you heard from Ms. Cook that she says after they unload the presents, they're in the house about 15 minutes. So give or take at 8:48 PM is when they arrive. You see that on camera. 15 minutes, we're looking at about 9:03, 9:04 PM. They're in the house wrapping gifts, which is when Tyrone goes outside and she says he's gone. No more than 30 seconds, she hears gunshots. That's when Robin grabs her gun, runs to the front door, hears running going to the left, so she follows him. And when she gets to the stairs, she sees a male in all black. She gets spooked. So she runs back. That's when she checks on Tyrone. She sees as she's coming down the stairs and laying lifeless in his car and runs to get her phone. And we know at 9:07, she calls 911. And at 9:10, first responders with the Atlanta Police Department arrive. And after the first responders arrive, you heard from the crime scene techs, Parker, as well as Detective McClure, that they begin their part of the investigation. They begin to process and photograph the scene, canvass the area for video surveillance, canvass the area for witnesses if there are any. Detective McClure told you he then started collecting as much video surveillance as he could. And defense counsel talked to you about if you want more video, if you wanted video of the shooting, and because we didn't have any, that's reasonable doubt. That's not reasonable doubt, ladies and gentlemen. There was no video of the shooting. There was, you can't get what doesn't exist. There absolutely was no video of the shooting, but that doesn't matter because he told you he did it. He told you that he shot and killed Tyrone. A video is not going to supplement that. Him confessing to shooting and killing the victim in this case isn't supplemented by any video. And again, if the video doesn't exist, it can't be given to you. Then you heard from Mr. Sengupta, and his testimony and the information that he provided to Detective McClure is unique and important because it's truly unbiased. When he makes the identification of the person dressed in all black as someone he's very familiar with and is able to provide all the contextual details about how he knows him, where he lives, his approximate age, when he graduated from high school, I think he said within 4 years of that date. He doesn't know that he's identifying anyone who did a shooting, that committed a murder. He's identifying somebody who looks familiar to him, that he knows the person in all black, which Detective McClure is then able to use to go to the Columbia Commons apartment complex to request additional video surveillance footage to get the leasing information for apartment 4104 to determine the identity of the male in all black, to determine that the person in all black is this defendant. He had no idea at the time his testimony was that important. He had no idea he was identifying anybody who committed a crime. He was identifying somebody in a video who came into his store that he was familiar with because of the frequency and the amount of times over the number of years that he had come. Then 2 additional shell casings are found on the 3rd floor after they were able to speak with Miss Beyonce Smith. And then they get the ring video. And that ring video is important for a lot of reasons. But it became even more important yesterday. It became even more important yesterday to prove that the defendant looked into each and every one of your eyes and lied. Lied, lied, and lied over and over again. And how did he lie? Because one in that ring video, you see him on the 3rd floor, he's already got his gun out. But what's important is the timestamp. He's passing on the third floor, apartment 1316 at 8:54 p.m. He's walking by. According to his story yesterday, he didn't get to the third floor until after this whole exchange with Tyrone happened, where he kneed him in the privates and all of the additional armed robbery that he described to you. That's when he said he got to the third floor. Well, that doesn't make sense. Because he would have encountered, if that was true, he would have encountered Tyrone as he was coming out, going to get the flyers for his gifts, which would have been well after 9 o'clock, like we talked about. That's how you know that the defendant was lying in wait, waiting and waiting for the opportunity to ambush and execute Tyrone. We know he did that. The why doesn't matter. The why does not make him any less guilty beyond a reasonable doubt of committing murder. Now, we also had a lot of other evidence that provided corroboration to each and every count in the indictment being proved beyond a reasonable doubt. And some of that was in the form of exhibits and testimony, which we talked about, the actual physical crime scene, and the technology, which is the video surveillance, but the science is important. And the science is important because it can't be changed. And again, we heard about the witness testimony of Ms. Cook, Ms. Smith, Ms. Winder, Mr. Sengupta, and how Mr. Sengupta's ID was important to the investigation and why, which we talked about. And here's the ring video, a screenshot that was provided from Ms. Winder as he walked past her apartment at 8:53:57 minutes after he had entered the apartment complex and it's been seen on the video surveillance. But according to him, yesterday went straight to one breezeway, the next one, and then 2 buildings over, I think is what he said. But that's not true. And we know that's not true because of the video surveillance evidence. I guess he forgot about that yesterday. He didn't remember that detail that came out during the trial before he started lying to each and every one of you. No mask on January 8th, even though it's cold. He only wears a mask when it's cold. And here is a picture of the crime scene like I was talking about earlier. And you can see how Mr. Hardesty's found, how his body lays. And it's important. It's important because it's clear from the evidence that first shot was the one in the back of the head. And he just fell. And the defendant kept shooting him. And you may be thinking, his pants weren't down at the time that he was shot, but it was clear he must have been sagging or his pants were low. And as it fell, his pants fell down because, like Dr. Sullivan testified yesterday, there were no holes in his pants when they examined his clothes. The holes were in the back of his sweatshirt, the hoodie of his sweatshirt, and then in his underwear, as you see there. So that's how you know the crime scene wasn't tampered with. That's how you know nobody went through his pockets, rifling for anything. No one went into the car looking for a gun. And Ms. Cook did anything nefarious other than be traumatized and terrified. That's how you know. The physical evidence that we have tells us everything you need to know in conjunction with what you saw on the video surveillance and the testimony and the exhibits that were admitted during this trial. And Dr. Sullivan told you there were 5 projectiles removed from the body of Mr. Hardesty. And what she told you is that they were all downward and that everything was back to front, except for what she said was the forearm gunshot. She described that as front to back. But as she explained what that meant, front to back in that relation was with palms up. Mr. Hardesty was shot with palms facing towards you, ladies and gentlemen, which means that he was shot from behind. Each and every shot he received on December 22nd of 2022, she told you the muzzle of the gun was to his back, was behind him. He was ambushed. This defendant ambushed him with a parade of shots, murdering him. She told you the ultimate cause of death was the gunshot wound to his head and to his torso, that the debilitating damage that it did to his body that was unrecoverable from it, and that the manner of death was homicide. And Brian Leopard, the firearms examiner, the expert in firearms, told you about the ballistics evidence that he examined from the crime scene and from the autopsy that was recovered. And he told you, he compared, which was placard number 3, the fragment that was found kind of near the vehicle, and the fragments that were pulled from the body of Mr. Hardesty, except for one, which was a lead core that couldn't be compared because it didn't have any unique characteristics because it was just a lead core. But the other 4, compared to that one projectile marker number 3, showed that they were all fired from the exact same weapon. So a projectile from the scene, projectiles from the body, fired from the same weapon, all 9mm caliber. He told you, he then compared the shell casings that were found below on the sidewalk with the shell casings that were found on January 4th after speaking with Ms. Smith, all 9mm, and he told you all fired from the same firearm. One gun. That's what he told you. So yeah, the shell casings were found a week later. So what? Thank God they were found. After they were found, they provided even more context, more information to prove that this defendant ambushed Mr. Hardesty. The timing of when they were found is not important. The fact that they were is. The fact that the investigation didn't stop is what's important. And the fact that those shell casings were used and compared to the shell casings found on the bottom floor, just outside building 1, and they were all fired from the same gun, is important. Now, during a trial, a lot can get mixed up. There's a lot of evidence, you hear a lot of facts, but the one thing you don't really hear, it gets lost kind of in translation. The one thing that isn't always the focus is the person who's lost. That states exhibit number 1, an in-life photo, Tyrone Hardesty. And on December 22nd, 2022, he was robbed of his life. His family was robbed of a family member. They were robbed of the hundreds of thousands of memories that they would have made with him had this defendant not ambushed him and shot him 6 times in the back. Senseless, cold-blooded murder. For what? For nothing. He stole Mr. Hardesty's life. He stole the memories that he had left to make with Miss Cook and his mother and the rest of his family. All as he ambushed him with a barrage of shots. As he was leaned into his car, just trying to get flyers to finish wrapping Christmas gifts. The one thing we all have in common around that time of the year, he stole that from Mr. Hardesty and his family, and they will never be able to celebrate another holiday or Christmas together, never be able to wrap another gift. Because of the actions of that defendant on December 22nd, 2022. It was an honor and a privilege to be before you this week. I know at times it was probably frustrating with the technology. I know at least I was frustrated. I know at times it may have seemed as if it dragged, but I know on behalf of the state of Georgia, as well as defense counsel and the judge, we thank you for your time. We thank you for paying such great attention during this trial. And I know that when you go back into the deliberation room and you talk about the facts and the evidence that unfolded the last 4 days, the only verdict that speaks the truth, the only verdict that the evidence proved beyond a reasonable doubt is that this defendant is guilty of murder, 2 counts of felony murder, criminal damage to property in the 1st degree, and possession of a firearm during the commission of felonies. Thank you.
Thank you, Mr. Abate. Ladies and gentlemen, we're going to take our morning break. I need to print one thing out before I can give you the jury charge. If you would, during the break, decide what you want to do about lunch. And by this, I mean, we can have lunch brought in. I think it's Rosa's Pizza, and take care of it that way if you want to deliberate and eat. But you also may say, look, we'll deliberate for a little while. When it's lunchtime, we want to get outside and disperse and not be together. So talk about that as a group. And I will give you the law that you must apply. And before you go back to begin your deliberations, you can let me know what your thoughts are about lunch. Okay? Don't talk about the case, no outside research. Get you back in here in less than 10 minutes.
All rise reserved.
What was the question? Mr. Abate, anything from the state before we break?
Yeah.
Ms. Feely?
There.
Okay, I'll be back out here in about 5 minutes. I just need to print out the final charge and the revised verdict form. I meant to say during the break, you guys should look through the evidence to see what goes out and doesn't, but we'll do that when I'm done charging the jury. I don't think it should be particularly controversial, but
I think everything, but I don't think defense quality is better.
I didn't either, but I wasn't going to interrupt anyone's closing. So just be thinking about that. And I don't know if the ME's report goes out either, but you guys can agree that those things do. And we'll just jump on that once the jury has the case. Mr. Abate, anything before the jurors come in?
No, Your Honor.
Ms. Feely,
There.
let's bring them in, please. I am giving to Ms. Rivers all 39 juror question cards that were submitted, those asked and not asked, and that will be Court's Exhibit 1.
All right, for the
Thank you.
jury. I'll do the president of the court.
Thank you, Deputy Gordon. Everyone else can be seated. So it's time for you to receive the law that you must apply to the facts as you find them to be. The law is contained in this document right here. This is called the jury charge. I will be reading it to you. I'm required by law to read it to you. You'll get this document, the thing I'm holding in my hands, along with this, the verdict form, more on that later, and as promised previously, the indictment. All those will go back with you for you to consider during your deliberations, along with the pictures and the shell casings and the things that have been admitted as evidence. But over the next few minutes, I need to read this to you. A few things about it. One, it will also be up on the screen. As I read, some folks process better if they can read what the person is saying. Two, because you'll get a copy, you don't have to worry about writing it down word for word. And three, there are some legal concepts that I am required by the higher courts, Court of Appeals, Supreme Court, to define in a certain way that may seem kind of stilted to you. I'm not intentionally using language like an abandoned and malignant heart, but you're going to hear me use that phrase because that's how I have to describe part of one of the elements of murder. So I do my best to make this accessible so that you and I and my kids would understand it. But there are certain legal concepts that have a phraseology that I'm required to give. And so in advance, I apologize if it seems like, why are you talking that way? It's because I have to do that. But otherwise, I try to make this as accessible as possible because it's basically the operating instructions for you while you deliberate. So without further ado, a grand jury has indicted the defendant in the form of this indictment for murder, felony murder, aggravated assault, criminal damage to property, and possession of a firearm during the commission of a felony. The defendant has entered a plea of not guilty to these offenses. Neither the indictment nor the plea of not guilty is evidence. The defendant is presumed innocent. This presumption remains with him unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. And I'll be giving you the elements for those crimes in a little bit. There is no burden of proof upon the defendant, and the burden never shifts to him. If a defense is raised by the evidence, and you've heard about an affirmative defense, self-defense, I'll talk about that later too. The burden is on the state to disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says, a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror honestly seeking the truth. It doesn't mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given, and that reason arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant grave suspicion of the crimes charged, or merely raises speculation as to his guilt, is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law, which is what's happening right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law I give you to the facts you find. You must decide this case based only on the evidence presented during trial. That evidence consists of, 1, all the testimony you've heard, and 2, the exhibits that were admitted. Evidence does not include the indictment or plea of not guilty, anything I've said or the lawyers have said to include their opening and closing remarks. And evidence does not include any questions posed. And that last part's important because in this courtroom, at least, jurors are allowed to submit questions. You may have submitted a question that did not get asked. That is not evidence of anything. Don't go back there during deliberations and say, hey, there must be something up because I asked this question and the judge didn't ask it. All that means is that it was not a legally proper question. It's not evidence of anything. Now, the evidence you've received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I saw the car run a red light and hit the pedestrian. I was right there. I saw it. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. 3 people walk through this door. They've got umbrellas. They're wet. We can't tell if it's raining. No windows here. That would be circumstantial evidence that it's raining. There is no legal difference in the weight that you may give to direct or circumstantial evidence. In considering all the evidence in this case, you may use your reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses. In deciding this, you may consider all the evidence, the witness's manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, and their interest or lack of interest in the outcome of the case. The credibility of a witness may be attacked by disproving facts to which the witness testified. If a witness's credibility has been attacked, you may also consider evidence offered to support the credibility of that witness. Your assessment of a witness's credibility may also be affected by comparing that witness's testimony to statements that he or she made before trial. You must decide whether there is a reasonable explanation for any inconsistency between a witness's pretrial statements and trial testimony. You heard from expert witnesses. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. However, the testimony of an expert, like that of all the witnesses, should be given only the weight and credit you believe it should receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided you find that witness's testimony to be sufficient. The state must prove the identity of the person who committed the crimes charged beyond a reasonable doubt. Your determination of identity is dependent upon the strength of the evidence offered for this purpose. A crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the specific intent to violate the law. I know the law prohibits X and I'm going to do this. It means simply the intent to do the thing that is in fact illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Knowledge on the part of the defendant that the crimes charged were being committed and that the defendant knowingly and intentionally committed such crimes must be proved by the state beyond a reasonable doubt. Criminal cases must be tried in the county in which the crimes were committed. This is what we call venue. And this question of venue, that is, were the alleged crimes committed here in Fulton County, must be proved by the state beyond a reasonable doubt. We're now getting into the elements of the different crimes. For murder, the state must prove three things. The state must prove that the defendant, number one, caused the death of another person. Two, that he did so unlawfully. And three, that he did so with malice aforethought. It's one of those phrases that I have to use. The killing must have been done with malice for it to be murder. Malice, as it is used for purposes of murder, doesn't necessarily mean ill will or hatred. What it is instead is the unlawful intent to kill. You may find this malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another. You may also find malice where there does not appear to be significant provocation and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, that is, with unlawful intent, it is a murder regardless of how briefly that malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act that killed, and that's what moved him or made him do it, that is enough for the killing to be murder. Proof of motive is not essential. It is not an element of the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the time of the killing. Counts 2 and 3 in the indictment charge felony murder. For felony murder, the state must prove that the defendant, number one, caused the death of another person. 2, by committing some other felony. The state does not have to show that the defendant acted with malice, that is, the unlawful intent to kill, to prove felony murder. Here, aggravated assault and criminal damage to property are felonies. You may find the defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of, this slide's wrong. Listen to me, not what that says. If he, by committing the felony of aggravated assault or criminal damage to property, regardless of whether he intended the death to occur. There must, however, be some causal connection between the felony, the aggravated assault, or the criminal damage to property, and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Voluntary manslaughter. In considering malice murder and one of the felony murder allegations, you must decide if the defendant was sufficiently provoked and acted out of passion. If you find this, you may not return a verdict of guilty of malice or felony murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter. The state must prove beyond a reasonable doubt that this offense of murder or one of the felony murder counts should not be reduced to voluntary manslaughter. Here's what voluntary manslaughter is. For voluntary manslaughter, the evidence must show that the defendant, 1, caused the death of another person, 2, under circumstances that would otherwise be murder, 3, and that the defendant acted only because of a sudden, violent, and irresistible passion that resulted from a serious provocation, that 4, was sufficient to excite the passion in a reasonable person. If you decide that enough time passed between the provocation, whatever that may have been, and the killing for a reasonable person to have cooled off and regained his judgment, then the killing is not voluntary manslaughter. You also heard about involuntary manslaughter. If you do not find beyond a reasonable doubt that the defendant intentionally shot or intentionally killed the victim, you should consider whether he is nonetheless legally responsible for that unintentional death. If you find this, you may not return a verdict of guilty of malice or one of the felony murders, but you would be authorized to return a verdict of guilty of involuntary manslaughter. The state must prove beyond a reasonable doubt that the offense of murder should not be reduced to involuntary manslaughter. And here's the definition of involuntary manslaughter. For that offense, the state must prove that the defendant, 1, caused the death of another person, 2, without intending to, 3, by committing the offense of reckless conduct. The defendant engages in reckless conduct when he causes bodily harm to another by consciously disregarding a substantial and unjustifiable risk that his actions will cause harm. And this disregard of the risk must be what we call a gross deviation from the degree of care a reasonable person would exercise in that situation. Aggravated assault. A person commits an assault when he attempts to commit a violent injury to another. A person commits an aggravated assault when he assaults another with a deadly weapon, and a firearm is legally a deadly weapon. Criminal damage to property. A person commits the offense of criminal damage to property when he knowingly and without authority interferes with any property in a manner that endangers human life. And the final crime alleged in the indictment is possession of a firearm during commission of a felony, which is pretty self-explanatory. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. And for this trial, murder, felony murder, aggravated assault, and criminal damage to property are all felonies. And firearm includes any handgun. The defendant has raised a defense that even if he committed the acts charged in the indictment, there were circumstances that justified his conduct. Once such a defense is raised, the state must disprove it beyond a reasonable doubt. Sometimes a defendant's use of force is legally justified, and so is not a crime. A defendant is justified in using force that is intended to or likely to cause death or serious bodily injury when, 1, he reasonably believes that the use of such force is necessary, and 2, he does so to prevent death or serious bodily injury to himself. The state has the burden of proving beyond a reasonable doubt that the defendant's actions in this case were not justified. If you decide the defendant's actions were justified, i.e. this was self-defense, then it would be your duty to find the defendant not guilty. A defendant is not justified in using force if he is attempting to commit or committing a felony. Felony includes aggravated assault, criminal damage to property, and murder. For a defendant's use of force to be justified, 1, the defendant must believe that his use of force is necessary. 2, that belief must be reasonable. That is, a reasonable person would also believe that the use of force was necessary. And 3, the defendant's reasonable belief must be what prompted him to use that force. A person who is not the aggressor is not required to retreat before being justified in using force he reasonably believes is necessary. A defendant is not justified in using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the victim for the purpose of avenging a past wrong and not for the purpose of preventing imminent death or serious bodily injury to himself, you would be authorized to convict. I want to talk about your verdict, should you reach one, and this verdict form. You should consider each count individually. The defendant may be found guilty of some, all, or none of the charges. If, after considering the evidence, together with this charge, you should unanimously, all of you, find beyond a reasonable doubt that the defendant did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty, and you would check that option on the verdict form for that offense. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him. In which event, the form of your verdict would be, we, the jury, find the defendant not guilty, and you would check that option on the verdict form for that offense. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing, and it will be. It'll be on this form, signed by your foreperson and dated. These are 2 excerpts from your verdict form. I just want to explain how it's going to work. For counts 1 and 2, you have several things you need to consider. It's not simply guilty or not guilty. Count 1 is murder, and you will be deciding if you reach a unanimous verdict, is the defendant guilty of murder? Was it an intentional, unlawful killing? Is instead the defendant guilty of voluntary manslaughter? Was he acting out of passion? He intended to kill, but there was this passion. 3, he didn't intend to kill anyone, but it was reckless conduct. That's guilty of involuntary manslaughter. Or 4, not guilty. Check 1 only if you reach a unanimous verdict. Do not check more than 1. For some of the counts, like count 4, aggravated assault, it's simply guilty, not guilty. If you reach a unanimous verdict as to aggravated assault, it's either the state proved beyond a reasonable doubt, guilty, you do have reasonable doubt, not guilty. Ladies and gentlemen, by no ruling or comment that I have made during trial have I intended to express any opinion about the credibility of witnesses, the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws given to you in this charge. It is your duty to consider the facts objectively, without favor or affection or sympathy for anyone. It is also your duty to report to me if you perceive that one of your fellow jurors is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You are not to concern yourselves with punishment. That is a role for the judge. One of your first jobs in the jury will be to select a foreperson who will preside over your deliberations and who will sign that verdict to which all of you freely and voluntarily agree. Please start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion with your fellow jurors and a careful consideration of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor, as was true throughout the trial, may you conduct any independent research. You have all the evidence in this case, and it would be improper for you to supplement it in any way with any outside information. To assist you and me in complying and enforcing that instruction, Deputy Gordon will be collecting your phones, your Apple Watches, your laptops, anything that connects you with the outside world. I promise we'll give them back, but while you're deliberating, you don't have them. You are focused on your job and the evidence and your deliberations. From here on out, should you need to communicate with me for any reason, you have a question, a concern, it must be in writing. Upon receipt of your question or note, I will confer with the lawyers and share with you whatever response I am allowed by law to give. And note that caveat. You may have a great question and my answer may be, you have to figure that one out, because there may be legal reasons why I can't answer your question in a more helpful way. Then that's on you. So I do my best to be helpful, and it's not meant to be sarcastic or sassy or non-responsive, but there are certain limits, like, hey, we don't remember. What do you remember about this? I'll say, no, it's your job to remember what that witness said, or sort out through your own deliberations how something happened. And with that, ladies and gentlemen, we are done with the charge. Did you all talk about what you want to do with lunch? It's only 11:15. Do you want us to order something? You want to handle your own lunch? Or do you want to meet as a group and let Deputy Gordon know within a few minutes?
Said order pizza.
You want us to order you pizza? All right. Nothing like a free lunch. All right. Ms. Nelson will consult with you all, so it's not anchovies. Someone may like that. It's not happening. It's not coming in the courthouse. We will order all of that. Mr. Thompson and Mr. Tavel, I need the two of you to stay here. You are part of the pizza group. You will get lunch, but I need the other 12 to go in the jury room. And if you need to move out of the way so the other 12 can go through, please do that. But the two of you need to stay out here, please.
All right, observe.
Right.
One second. All right. You gentlemen are alternates. So you were here and remain here in case we lose one of those 12. You're going to be here today as long as these jurors deliberate. If for some reason they don't finish today, before we end for the day, we'll talk about whether you need to be here next Tuesday, or if your work or home situation is such that you could get down here if we needed to have you parachute in. Because if we lose a juror, one of you replaces that juror. It would have been invisible to you all if because something happened to Mr. Newman is one of our jurors. And if we lost Mr. Newman, you wouldn't have known it, but one of you would have slid into a non-alternate role. We don't tell you that in advance because you might pay a little less attention if you knew. I'm the backup, I'm the understudy. And you're not. You heard all the evidence in the very same way that everyone else did. There's a jury room over there where that deputy is standing, where you will be. You get to keep your devices. You may not do outside research. You may not start reaching out to people saying, hey, I'm done. Let's talk about this, because you're not done. You are on reserve in case we do lose someone. So you can go into the jury room in just a second to grab your stuff. And then when it's time to figure out what we're ordering and all that lunch stuff, I'll make sure Ms. Nelson or Deputy Gordon checks with you all as what's not individual pizzas. It's going to be a bunch of pizzas. But when the food arrives, they'll stop their deliberating. You'll go in there and grab your stuff. They may want to deliberate while they eat. That's okay. But if they're deliberating, you can't be in there. If you replace a juror, they actually have to start all over again. So don't think, wait, what am I missing out on? The law that I will give the jury as reconstituted, because one or both of you have to go in there, is square one. And they may get you up to speed, but it really is starting all over because neither of you will have been in there for those discussions. It is extremely unlikely that today we will lose one of those jurors. It would have been something that would have come up during the week before now. But that's the situation. Any logistical questions? Okay, if you go in the jury room and get your stuff, you don't have to yield your electronics, and you'll head on over there. Mr. Abate, anything you need to get on the record following the jury charge?
There
Ms. Feely?
No.
Okay, if you would confer about exhibits, let's do that. And then Deputy Gordon can get everything, excuse me, to the jury.
we conferred, we just agreed to let it all go back.
Okay,
That way now, first one.
can you give him a wave? There you go. Wasn't a very enthusiastic wave. All right, so it's clear on the record, Mr. Abate, you have no objection to everything going out that was admitted.
That's correct.
Ms. Feely, same?
Yes, same.
That makes it easy. Great. When Deputy Gordon is back, I will give him the verdict form, the indictment, and the jury charge to add to that, and he can get everything to them. If you all could, this is a blank note card, write a phone number, one for the defense, one for the state, that we can call if you're not in here and we need you here. We have a plea at 1, so I'll see you for sure at 1. I think, is that not your case? Maybe it's Ms. Willingham's. Okay, well, I'll be here at 1 for a plea if there aren't questions or other issues from the jury before then. And then I have a hearing at 2:30, but all those things will be stopped if the jury has something we need to address. Okay, and Mr. Williams, you will be brought out every time and anytime there's a question from the jury or anything like that. It's not that Ms. Feely will come back and tell you what happened, but you'll be out here for all those discussions. Okay?
Okay.
That's it. Thank you. So everything's going back and this goes with it. I will mute the mic in here and we'll go from there.
I said he was going to the office or something.
A body? Should I call him?
Yes.
Okay. Hey, Mr. Sharp, can you hear us?
I can.
Great.
Good afternoon. I believe I have everything on to have my screen on. I don't know why I'm not showing a video image of myself.
Yeah, me neither. There's a camera with a slash through it. That's not what you normally look like, but
Well,
I
let
bet-
me tell you, maybe. Oh, okay. It was on my end. I'm bad.
there you are. Great. Hey, here's my question. I know that you have some scheduling constraints, and I want to be respectful of those. I have two questions from a jury that's deliberating. Do we have time? They don't need to come out for this. I just need to consult with the lawyers and the defendant and come up with a written response. Can we do that and still do that first and still take the plea, or are you not able to do that?
No, absolutely. I'll work with you because I mean, you know what's going on. I'm difficult to get a hold of nowadays, anyways. So I just say let's get it done today.
Great. And then the victor who is on the call, that's Mr. Ochanda?
I would assume so. I'm not seeing that on my end. Oh,
Okay.
yes. Mr. Ochanda, could you please put your video on? There we go. That is him.
Excellent. Okay, then you guys can be at ease for a few minutes. I got to track down Mr. Abate, and we'll answer these juror questions, and then we'll pivot back to you. And I see Ms. Willingham is on as well. So we've got everyone we need for the plea. I'm ready for that. Ms. Rivers is here in court, but let me get our prosecutor and answer these two questions, and we'll get back to you. Thank you.
All right, great. And Victor, make sure you put yourself on mute while the judge is dealing with this other issue.
Sorry.
No problem. Ms. Rivers, are you ready? We are back on the record in State versus Williams. The jury is deliberating. They have two questions so far. The first reads, if someone does not intend to damage property during a shooting, but knows they damaged property, is the shooter guilty of criminal damage to property? If someone does not intend to damage property during a shooting, but knows they damaged property, is the shooter guilty of criminal damage to property? Question 2. What's the difference between knowingly and complete disregard? What's the difference between knowingly and complete disregard? Man, you could write an essay about both those, but we're not going to do essays. My suggestion for the first question is to lift an excerpt from the intent charge. And that is that intent may be inferred when it is the natural and necessary consequence of an act. Do you have any objection to that, Mr. Abate? Ms. Feely?
What is the whole charge? Is that the whole thing?
I'll put it on the screen. And I don't mean for you to be working in the dark there. It's a good question. But to be clear, I didn't like omit like the word not or something. Is it on the screen now? There we go. So there's intent. Is your screen not working?
It is, but
Okay,
just wanted him to be able to see.
your problem.
Whatever it is.
I wonder if it's even connected. It's different.
So we would want to include
I'm sorry, include what?
the next part. The defendant is not presumed to have acted with criminal intent, but you may find such intent or the absence of it
Okay.
would be our request.
What if I say, rather than give him the whole intent charge, because I think there are two pieces that are, I think the one that is most responsive is what I read, but I think that it is balanced to say the defendant is not presumed to have acted with criminal intent. So what if I say intent may be inferred when it is the natural and necessary consequence of an act? Remember, the defendant is not presumed to have acted with criminal intent. You all right with that, Mr. Abate?
Yes, Judge.
Okay, let me write that. Did you get pizza? You get pizza? All right. So in response to question 1, if someone does not intend to damage property during a shooting, but knows they damage property, is the shooter guilty of criminal damage to property? I'm acknowledging I'm not directly answering it because we don't decide whether the state, I don't think it's appropriate to say whether the state met its burden, but I think a responsive and helpful answer is, as mentioned, intent may be inferred when it is the natural and necessary consequence of an act. However, the defendant is not presumed to have acted with intent. Mr. Abate, that work for you?
Yes, Your Honor.
Ms. Feely?
Yes, sir.
All right. What's the difference between knowingly and complete disregard? I looked up the word disregard and it comes up only twice in the charge I gave. It is involuntary. It's on the screen now. And there's not a complete disregard. There's a conscious disregard. My thought would be to say those words have their common English meaning, or something to that effect. Or as used in the jury charge, those words have their standard meaning. I don't think they're specialized terms. It's not like malice. You all right with that, Mr. Abate? Ms. Feely? All right, so again, the question was, what's the difference between knowingly and complete disregard? Answer, as used in your charge, those words have their standard English meaning. All right with that, Mr. Abate? Ms. Feely? All right, Deputy Gordon will deliver those to the jurors, and we will pivot to Mr. Ochanda. Let's get on the screen, Mr. Shart, Mr. Ochanda. There he is, and Ms. Willingham is gradually coming to life. There she is. Well, you got a real bright light behind you. It's like you're in heaven. Whoop, you just covered it with your head. All right, and you're muted.
Okay.
Great. All right. So, Mr. Ochanda, we need you to be unmuted as well, and then we should be off and rolling. Okay. Ms. Rivers, are you ready? This is 23 SC 188312, State versus Victor Ochanda. Mr. Ochanda is represented by Mr. Sharp, who has had a few glorious days off from his primary occupation. Ms. Willingham represents the state. Mr. Ochanda, in a moment, Ms. Willingham is going to put you under oath so we can move forward with this plea conversation, but I need to get a couple things from you on the record first. You have a right to be here in court in Fulton County, Georgia. You're not, you're somewhere else. I think you're out of the state, but either way, you're not here in the courthouse. Are you okay appearing and proceeding remotely the way that you are?
Yes.
Yes, great. And you need to make sure you answer out loud because that's what the court reporter has to write down. Second, you have a right to have Mr. Sharp right next to you so that if you've got a question, you can lean over and say, what's the judge talking about? He is where he is, you are where you are. And that's fine as long as you tell me you're okay with that setup. Are you all right?
Yeah, yes, Your Honor.
Okay. If you need to speak with him privately, just tell me and I'll drop you guys into a breakout room where you can speak and no one else can hear it. Okay?
All right.
Great. And Mr. Ochanda, no one has asked for an interpreter. Are you good moving forward with no interpreter?
Yes, Your Honor.
Okay, great. Ms. Willingham, when you're ready.
Please raise your right hand. Sorry, I forgot to minimize, so I can't see this. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. Please state your name, your age, and your date of birth.
Victor Ochanda, February 6, 1997.
Are you now under the influence of any medicine, drugs, or alcohol?
No,
How far did you go in school?
some college.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Last year, but currently I didn't, I've not looked at it.
But you did have an opportunity to review it last year with your attorney or on your own accord by direction of your attorney?
Yeah, yeah,
Okay. Do you fully understand the nature of the charges pending against you?
yes, ma'am.
By pleading guilty today, you're giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that count 1 would be reduced to disorderly conduct with 12 months probation. Count 2 of the indictment would be non-pressed. You would be required to have no contact with the victim, complete family violence intervention program, complete 50 hours of community service, and write an essay on consent. Is this what was explained to you by your attorney?
I mean, yeah, but I didn't get all the details unless I have talked with you.
I did not mention to him, and I neglected to talk about the writing an essay portion. And also, Ms. Willingham, I believe that the agreement is 11 months probation.
You're correct. That was the amended part. Yes, it is 11 months probation. Is the essay going to be an issue?
Mr. Ochanda, what I neglected to say to you was that the state would also like you to write a short paper about consent. Okay, consent in relationships. Is that something that you can do?
Yeah, I can.
Okay. Do you have any more questions at this time regarding the negotiations, Mr. Ochanda?
No, but if I have, I'll ask my attorney.
Okay. You're pleading guilty today to disorderly conduct, which has a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
Apart from my case?
No. Yes, apart from this case.
No.
Okay. You heard me tell the court what the negotiation is in this case, which is 11 months probation, no contact with the victim, complete family violence intervention program, complete 50 hours of community service, and write a short essay on consent. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 12 months in custody?
Do you understand that, Mr. Ochanda? Meaning, I'm not bound by these negotiations. I could hear more about the case and say, I don't think 11 months probation is the right sentence.
I mean, I'm okay with the sentence, but I didn't get the full details, you know?
So two different things, Mr. Ochanda. I understand that you hadn't heard about the essay. This is not a question about the details of the sentence. The question is, do you understand that I am not part of the negotiations. And so I might decide that you should have 5 months of probation. This just isn't, he doesn't need more than that. I also could decide, no, you need all 12 months of probation, or maybe you need 6 months of probation and a month in jail. And I'm not giving you all these examples because I'm unsure about things. I usually follow the recommendation, but it is merely a recommendation to me as to what I ought to do. Do you understand that?
Yes, sir.
Great.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. And under the special conditions, as previously discussed, you would be required to have no contact with the victim, complete family violence intervention program, complete 50 hours of community service, and write an essay on consent. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Your Honor, can I just suggest one thing? And I know Victor's wondering about this. I'm going to ask Your Honor to order that the probation, the misdemeanor probation, he be allowed to report via phone. And I know he's concerned about this because he has relocated to Springfield, Massachusetts, and he's working there and he's living with family there. So I'm going to ask that. I'm also, in Victor, I see the look on your face. I'm also going to ask that the no contact be no violent contact. And the reason is, quite frankly, I believe that the alleged victim has been contacting Victor, and they do have a child together, and she does want to continue to receive some financial support that Victor can provide to the child. So those are the two things that I think probably Victor is concerned about. Is that fair, Mr. Ochanda?
Fair.
Okay, well, when we get to it, I'll engage Ms. Willingham with the no contact versus no violent contact. In theory, she's the one who's been communicating with Ms. Huddleston, and would be in a position to say the state opposes that or the state's okay with it. But I've made a note, telephonic reporting, and then we'll sort out the degree to which contact is limited as a condition of this sentence.
Yeah.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No.
Are you satisfied with what your lawyer has done for you in this case?
Yes.
Do you have any more questions for your lawyer before we go on?
Not at the moment.
Have you
Ms.
understood?
Willingham, I know this is a little unusual for a misdemeanor, and I spoke to Victor about this yesterday. He does wish for the court to consider sentencing him as a first offender for the disorderly conduct. And he's been fully advised.
Yeah, and I'll leave it at the court's discretion, but I will read that portion when I get to it as well.
Okay.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No.
Have you understood everything I have asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to this charge today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offense to which you are pleading guilty?
Did I do what?
It's disorderly conduct, Victor.
I mean, I did hear the question fully, so if she can
Did
repeat.
you in fact commit the offense to which you are pleading guilty? Did you in fact commit the disorderly conduct?
Yes, ma'am.
Are you a United States citizen?
Not yet.
Do you understand that by pleading guilty today, there's a possibility that you can be deported from this country?
I've had it, but I don't know how it works.
Yeah.
So let me interject here, and then I'll let Mr. Sharp go after that. So here's the important part of the topic about citizenship and residency, Mr. Ochanda. The reality is no one knows for sure what will happen by this guilty plea, but you have likely spoken with folks who know a whole lot about the topic. That may be Mr. Sharp, that may be a lawyer he spoke with, it may be a lawyer you spoke with, but no one knows for sure what the government, the US government, might do with your plea. And that's what Ms. Willingham is just trying to let you know, that if someone has promised you, no matter what, this will not affect your effort to become a US citizen, that person's not being honest with you because there's no guarantee. I can tell by the way this is being structured, 11 months probation and not 12, and a misdemeanor and not a felony. People who know a whole lot about immigration law are giving you good advice about how to put this together. And so it is likely that this will have no effect on any efforts you're making to become a naturalized citizen or anything else. But I would be misleading you if I left you thinking that everything is perfect. There is always risk. And so you need to understand that this plea brings risk into the question of, could you become a US citizen? Certainly less risk than a plea to what you were originally charged with. Does that make sense?
Yes, Your Honor.
Okay, Mr. Sharp, what did you want to add?
And you explained it perfectly, Your Honor, but I'll just add that I have consulted on Mr. Ochanda's behalf with an immigration attorney that I trust, and it has been structured in a way to minimize any risk.
Okay, but that's the critical word, is minimize, not eliminate risk, but minimize risk. And as long as you understand that and you still want to go forward, then I'm happy to accept your plea. Do you still wish to go forward, Mr. Ochanda?
Yes, Your Honor.
Great. Ms. Willingham.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
The petition for what exactly?
This is the Victor. I don't know if you remember this. This is the habeas corpus. If you want to challenge the plea, you have 12 months because it's a misdemeanor. If you want to challenge the constitutionality of the plea. Okay.
Okay.
It is my understanding you are requesting from the court to be treated as a first offender. There are benefits and risks to requesting this status. Benefits are that if you do what the court orders you to do and do not violate the terms and conditions of your probation, you will not have a conviction for these offenses. Risks are that if you violate this sentence or your probation, commit a new offense, etc., we will ask that you be brought back into court.
Stop for 1 second. Hey, we're taking a plea, so if we could just keep it quiet. Unfortunately, folks are virtual. Thank you. That's okay.
Risks are that if you violate this sentence or your probation, commit a new offense, etc., we will ask that you be brought back into court and ask that you be adjudicated guilty, meaning you will have a conviction and the court can re-sentence you up to the maximum sentence we discussed earlier, which is 12 months in custody. Knowing all of this, do you still want to be treated as a first offender?
Are you able to repeat the statement once more again, please?
It is my understanding you are requesting from the court to be treated as a first offender. There are benefits and risks to requesting this status. Benefits are that if you do what the court orders you to do and do not violate the terms and conditions of your probation, you will not have a conviction for this offense. The risks are that if you violate this sentence or your probation, commit a new offense, etc., we will ask that you be brought back into court and ask that you be adjudicated guilty, meaning you will have a conviction, and then the court can re-sentence you up to the maximum sentence we discussed earlier, which is 12 months in custody.
May I, Your Honor? Just
Yes, sure, because I know you two have talked about it.
Right. So, Mr. Ochanda, remember when we discussed first offender treatment, and I said that there's a good side and a bad side to it. And I said the good side is if you do your probation as you're supposed to,
Mhm.
it will not be a conviction on your record. And you like the sound of that, but I also warned you if you don't do what you're supposed to do on probation, you can be resentenced up to the maximum, which would be 12 months to serve, which also, if that happened, could potentially create some immigration issues for you. So I suggested that you not take first offender, but I also told you the choice was yours.
Mhm.
Okay, so you can make that decision. I let the court know that it was your desire to do first offender based on what you told me.
Mhm.
But is that what you wish to do?
Oh, yeah, that's what I wish to do. But okay, can I do it? I mean, can we do the first offense after I've done the punishment for 11 months? And
So that's a great question, but the way it works is that I have to sentence you one way or the other. I have to sentence you either as a first offender, which means you don't have a conviction. And so for 11 months, assuming you have no problem staying out of trouble, you'll be under a sentence, but you have no conviction. And if you successfully complete it, it all gets wiped away. But it carries the risk that Mr. Sharp mentioned. If you do get into trouble during those 11 months, not only will you have whatever your new situation is, but I could revoke your first offender, resentence you up to the maximum, which is 12 months, potentially in jail. And as you've probably figured out, a sentence of 12 months is much more meaningful on the immigration front than a sentence of 11 months. So there is a risk associated with it, but the benefit is, if you are confident that you can stay out of harm's way and stay out of trouble for 11 months, then you have zero criminal history. You can get it all expunged.
And complete what you're supposed to do on probation, not just stay out of trouble, but complete what you're supposed to do on
Right.
probation.
Do the community service, do the family violence intervention. If you do all those things within those 11 months, that is exactly right, Mr. Sharp. So it's your decision. Mr. Sharp's given you his perspective on it. But ultimately, I'm going to ask you whether you want to be sentenced as a first offender or if you want this to be a misdemeanor conviction.
Your Honor, I have a question.
Yes.
So regarding the misdemeanor, so let's say I don't use my first offender act, right? And then I finished the probation without any, any issues. How long, I mean, will I be able to expunge the misdemeanor after 4 years, or it will just be on my record permanently?
That's a question for Mr. Sharp. I don't get involved with those things.
My understanding of the law, Victor, as we discussed, is it would be on your record permanently, and that's what you need to consider. You need to assume it will be on your record permanently.
As opposed to the first offender, in which case it would not be on your record. So that's the benefit of first offender, not on record, but there's a risk. And if you, so that's just something for you to think about. So why don't you keep going, Ms. Willingham? I'll give Mr. Ochanda a chance to think about it. I will ask him when it comes time to imposing sentence, which direction he wants to go.
Okay, have you ever used first offender in any other case or any other place, Mr. Ochanda?
No, ma'am.
Okay. Your Honor, should the state proceed forward with this case, the state—
Your Honor, we're willing to stipulate to a factual basis. We are willing to stipulate.
Okay.
And
you all right with that, Ms. Willingham?
yes, Judge, I am. I will then just explain to the court the reasoning. I know that the court has seen what the charges were,
Right.
and what the state has done with those. I have spoken at great lengths with Ms. Huddleston. We started speaking probably when I first got assigned to because I think I got this case around the time I originally got assigned to your courtroom. So it's been a little more than a year that Ms. Huddleston and I have spoken back and forth. And she, from the very beginning in speaking with me, has been very consistent in that she would not be willing to come back to the state of Georgia to testify, even if we paid for her to travel here. She was very adamant about that. She does not deny that this incident occurred, but she stated that it is too hard for her to have to relive it. She does not have any desire to. We offered several services to try and help her get counseling, and we were hopeful that that might be able to get her to be a little bit more of an active participant in this case, but she has maintained that she is not willing to come back. She's been more than willing to talk to me over the phone, but has made it very clear that even if they paid for her to get a plane ticket, she would not show up to the airport. And without Ms. Huddleston, the state would not be able to move forward on this case. So based on that, she was okay with us doing a misdemeanor offer on it and a probation offer. I spoke with Ms. Huddleston yesterday, Your Honor, and it is my understanding that she does not necessarily plan to contact the defendant directly regarding financial support, but it is my understanding from my conversations with her that other than the defendant reaching out to her, I believe there have been, and that was in reference solely to their child. There has been no other communication. So I am not aware of her wanting to maintain the communication. When her and I first spoke about the negotiated plea, it was a no, she wanted no contact. So I would maintain that. I do submit to the court that there is a minor child, and I do know that she does plan to proceed forward regarding financial support, but it is my understanding she does not necessarily plan to do that directly through the defendant.
Okay,
So, in Your Honor, and I know that myself and Miss Willingham are just like attorneys on the outside looking into this relationship. So I'm not accusing Miss Willingham of misleading anyone, of course. I've seen texts, and of course, when I saw the text, my advice to Victor has always been, don't respond. We got to figure things out in court. But I've seen text and like I think they were Cash App requests and things like that. And I don't think Mr. Ochanda is in a position where he's saying, "Oh, I don't want to support my child." Of course, he wants to support his child. So I just think I would just, if it's a little bit ambiguous and the waters are muddied about the conversations, I don't have any problem. Mr. Ochanda's in Massachusetts. He has no desire to see Ms. Huddleston in person. But if there's potentially some communications regarding financial support and things of that nature, I just don't want those communications to come back and haunt Mr. Ochanda, because from my understanding, those communications, at least from Mr. Ochanda's perspective, are from a place of good intentions.
what state does Ms. Huddleston live in?
Florida.
Okay, all right, I got it. You can keep going, Ms. Willingham.
Your Honor, and that would conclude the state's portion.
We do not have pretrial services on. Did you get a chance, Ms. Willingham, to look at Mr. Ochanda's criminal history to see if you think he qualifies for first offender?
I did, Your Honor, and per my review, the defendant has no prior history and does qualify for first offender.
Okay, thank you. Mr. Sharp.
Your Honor, may it please the court. This is a complicated case with a complicated relationship. There's reasons why I could see Mr. Ochanda wanting to fight this case. I also think that the risk is very high, and I support his decision to resolve the case. I will say that Mr. Ochanda, to my understanding, has no criminal history. He's never been into trouble. He immigrated here from the continent of Africa, and I believe Kenya. That's correct. from Kenya, and he has family here. He has family in Massachusetts. He's been working hard. He's gone through some times during his bond where he's been homeless, living in a car. And he's been working hard doing construction, and he's in Springfield, Massachusetts with his grandfather, and he's a hard worker, and he has aspirations of obtaining his CDL and going into the trucking business. So I think his intentions are good. And I think he's going to stay out of trouble. So,
Mr. Ochanda, I'll let you wrap up if you have more, but I just dawned on me. Are you wearing an ankle monitor?
Yes, Your Honor.
So, and you're
How are we going to get that off?
well. So, Mr. Ochanda, Miss Nelson was diligently trying to set up this plea, and so my thought on it is Mr. Ochanda is going to have to either purchase a plane ticket or drive down here in the immediate future to get that taken off from by pretrial. And I told him that. I know that he was hoping to avoid a trip down here, but once we realize that the ankle monitor is still on, we understand that has to be done in person.
Right. That's an expensive piece of equipment. I bet you want it off. The way it comes off is by you coming down here to get it off, Mr. Ochanda, okay?
Sure.
All right. Did you have anything else, Mr. Shard? I didn't mean to interrupt, but I just looked up his bond and saw the ankle monitor.
That's what I was going to discuss with Your Honor, the ankle monitor situation.
Okay. All right. Mr. Ochanda, do you have any questions? You're on mute. Did you have any questions?
Not at the moment.
Okay. What is your decision about first offender? Do you want to be sentenced as a first offender or not?
Yeah, I want to do that. If that's the only option we have, I'm okay doing it because I know myself. I never got myself to trap, and I don't want that to haunt me in the future.
Okay. Well, you are the best decider of that. That's why I asked you and not Mr. Sharp. You know if you're going to stay out of trouble or not. Sounds like you do just fine taking care of what you need to take care of. Mr. Ochanda, I find there's a factual basis for your plea to disorderly conduct in count 1, and that your plea is knowing and voluntary, so I will accept it. Mr. Sharp, can we sign your name to the indictment?
Sure.
Ms. Willingham, can we sign for you?
Yes, Your Honor.
Mr. Ochanda, it looks like you've got a question.
Yeah, I have a question regarding the community service. I don't know how am I going to do it because I live in Massachusetts.
Well, the good news is that there's community service to be done everywhere, and you will just need to find a location in Springfield, whether that's working at a food bank or helping clean up a park through the city or who knows what. But people perform community service in all 50 states. You do not need to come down here to do your community service. The only reason why you need to come back to Georgia is to get that ankle monitor off. But as long as you can get documentation of your community service, you can do it in Massachusetts. You'll want to talk with probation, and I'm going to set as a condition of your probation that it be telephone reporting, meaning you just talk to them on the phone, but that you can email them. And so you may say, here's my plan for community, going to do this work at this church. And you would be, as long as it's documented that you were doing it, you'll get credit for that. Okay.
Okay. Yeah, no problem.
Mr. Ochanda, can someone from my office sign the indictment on your behalf?
Yes, Your Honor.
Okay, and you do want to be first offender, and you understand, we've talked about it before, but it merits repeating, that while this is unlikely to affect your efforts to become a U.S. citizen, no one can promise you that it will not. You understand that?
Yes, Your Honor.
Okay. I will follow the joint recommendation, sentencing you to 11 months probation on count 1. I'm going to set the question of contact of no direct, as in person to person, no physical contact with Ms. Huddleston. So you can write her, she can write you, you can call her, she can call you, but you cannot be in the same place as Ms. Huddleston. So if she's in Florida, just don't go to Florida, then you don't run that risk. But no immediate physical contact with Ms. Huddleston. You'll need to complete a family violence intervention program. You'll need to complete 50 hours of community service and write an essay on consent in relationships, why it's important that both people consent to whatever's going on in that relationship. Do you have any questions about that sentence, Mr. Ochanda?
No.
Mr. Ochanda, you'll be on misdemeanor probation. Mr. Sharp is going to send you the way you sign up for that and the way you contact those people. You need to reach out to them. If you do not, they're going to send me a warrant and I'll sign it because it means you have not gotten involved with probation. So make sure that you do that. And I am sentencing you as a first offender. Ms. Willingham, do you have anything else in Mr. Ochanda's case?
Nothing further, Your Honor.
All right. Mr. Sharp, anything else?
No, Your Honor.
Mr. Ochanda, last chance. Any questions? Anything else you want to know about or you want to share with me?
Yeah, I mean, if you can allow me, I would like to ask something that has been, troubling me. Besides the First Offender Act, what are the other options that I can potentially use to get rid of this charge from my record after I finish my probation?
So you and Mr. Sharp can talk about that offline. We're not going to talk about that in a large group setting, but first offender is probably the most direct way because it's not on your record. Even though you've pled and you are now under sentence as a probationer, there's no conviction. So if you can manage for 11 months to stay out of trouble, then you will have done what you wanted to do. Okay?
Okay.
All right. Anything else?
Can I have a talk with Mr. Sharp for a minute, please?
So what I'm going to do is have you two talk on the phone because we're all done. I need to remind you that you are going to have to come back to Georgia to get that ankle monitor off. In fact, I'm going to add one more condition to your probation, and that is that you need to get the ankle monitor removed within the first month of your probation. So you've got 30 days from today to come down to Georgia, bus, plane, bicycle, however you're going to do it, so that that ankle monitor can be removed. You've got 1 month to get it removed, okay?
Yes, Your Honor. And where am I going to get it removed?
Mr. Sharp can help you with that.
Okay.
All right?
All right.
All right. Ms. Willingham, thank you for your time. Mr. Sharp, enjoy your weekend. I need the three of you, you can stay on, but I'm using this Zoom feed for other things that are going on. So if you all need to talk in any other way, you should just sign off, which you're free to do, and get each other on the phone. Okay?
Thank you, Judge.
All right. Take care. All right. Ms. Rivers, let me know when you're ready to pivot to the Williams matter. We need to get him out here. Okay? All right, Deputy Gordon, it's my understanding that the jury has told you they've reached a verdict. Okay, Mr. Abate, anything we need to discuss before the jurors come out? Ms. Feely, anything we need to discuss before the jurors come out? All right, for those people in the gallery, you are welcome to stay in here. It is imperative that you process the verdict, whatever it is, quietly. If you think it's going to be difficult to process the verdict, you should wait outside and someone can tell you 2 seconds after the verdict is announced what that verdict is. But if you're concerned that you might have any kind of visible, perceptible reaction to the verdict, I need you to not be in the courtroom. That's not fair to the jurors to have people reacting in that way. So feel free to stay if staying is something you can manage. All right? Let's bring the jurors in, please. Pretty quick with the final disposition. I meant to give you the disorderly conduct statute, but you got it.
All rise for the jury. Mr. President of the County Court.
Thank you, Deputy Gordon. Everyone else should be seated. Ladies and gentlemen, it's my understanding that you all have reached a verdict. Is that correct? Are you the foreperson sitting all by yourself in the corner? If you could give your verdict, please, to Deputy Gordon. Right, sir. I would ask the foreperson to stand. Did you and your colleagues reach a verdict?
Yes, we did.
And was that a unanimous verdict?
It was.
All right, if you would please, and you filled out the verdict form and signed it and dated it?
I did.
Okay, then if you would please read the verdict into the record. You can just start count one, whatever the verdict is, and work your way down.
All right. Count one, murder. We, the jury, find the defendant guilty, murder. Count two, felony murder, aggravated assault. We, the jury, find the defendant guilty of felony murder. Count three, felony murder, criminal damage to property. We, the jury, find the defendant guilty of felony murder. Count four, aggravated assault. We, the jury, find the defendant guilty. Count five, criminal damage to property. We, the jury, find the defendant guilty. Count six, possession of a firearm during commission of a felony. We, the jury, find